Okay, a very good morning to all of you. I hope I am audible. Okay, so I, Dr. Charu Goyal, on behalf of Indian Institute Council, Indian Innovation Council of IIIT Nagpur, welcome you to this event of celebrating World Intellectual Property Day, as you can see in the poster. But let me give you a bit of details. So, World Intellectual Property Day is observed annually on April 26th, and its aim is to raise awareness on how patents, copyrights, trademarks, and designs impact on daily life, and to celebrate creativity and the contribution made by creators and innovators to the development of economies and societies across the globe. In 2023, that is this year, today, the World Intellectual Property Day celebration has a special theme, which is Women and IP, Accelerating Innovation and Creativity, where we celebrate the can-do attitude of women inventors, creators, and entrepreneurs around the world and their groundbreaking work. In this spirit of celebrating innovative, creative, and enterprising women around the world, today we have with us Dr. Divita Page. Dr. Divita's research and teaching interests include intellectual property rights, criminal law, and constitutional law. Having completed BA LLB from ILS College, Pune in 2016 and LLM in intellectual property rights from Indian Law Institute, New Delhi in 2017, she has completed her doctorate in law from MNLU, Nagpur in the field of intellectual property rights. She has participated in national seminars and workshops pertaining to her areas of interest and has been a member of organizing committees of several events organized by the university. Today she is going to enlighten all of us on the topic of intellectual property law for engineers and technologists. So I welcome Dr. Divita Page to come and enlighten us with the topic of her interest, and at the end of the talk you all will be welcome to ask questions. Okay, so let's welcome.
Thank you, ma'am, for the warm introduction. Very good morning to all of you. I'm really glad to be here with you today to discuss with you on the topic intellectual property law for engineers and technologists. Yes, so to begin, all of you need to understand what is intellectual property. Now, intellectual property, like the very name suggests, is property which is created by using the mind. Anything that you create by using your mind, when you are taking notes in the classroom, it is a creation of your mind. When you are making a drawing or a painting, it is a creation of your mind. When you are making a scientific invention, it is a creation of your mind. Whatever is created by your mind becomes your property. Now, what do you understand by property? When we use the word property, commonly what comes to our mind is physical property, meaning land or a mobile phone, a movable or immovable property that we own. So whenever we say something is our property, it means that we have certain exclusive rights concerning that property. If you are the owner of a land, if that land is your property, it means you alone, to the exclusion of everybody else, have the right to use that property, to sell that property, to transfer that property to another person, to the exclusion of everyone else. You have the right to prevent any other person from using your property. It is your private property. You have the exclusive right to sell that property in whichever way you want. You have the exclusive right to commercially exploit that property in any manner you wish. That is what we mean when we say that something is your property. Now, similarly, in case of intellectual property also, when there is a property which is created by you using your mind, law provides you with the exclusive right to commercially exploit that property. If you have written a research paper, if you have made a scientific invention, if you have created anything using your mind, your intellect, you have property over that creation. What does property mean here? Property means the exclusive right to deal with that creation. The right to prevent everybody else from dealing with that property. Law confers you with certain exclusive rights concerning the creation of your minds, and that is why we say that the creation of your mind becomes your intellectual property. Now, it is very important, however, to understand where your intellectual property lies. If you have written a book, if you have written a book and there are multiple copies of that book which have been printed, what is your property? Your property does not lie in the jacket of the book. If you have written a book, you have a copy of that book in your possession. I come and steal that book from you. I take that book from your possession without your consent. What have I stolen? Have I stolen your physical property or your intellectual property? I have stolen your physical property. Your physical property lies in the book because you have paid a certain sum of money to purchase that book. By stealing that book, I have not stolen your intellectual property. However, if without your consent, I am copy-pasting the contents of that book in a research paper that I write and passing that off as something that I have written, then I have stolen your intellectual property. It's important to distinguish between the intellectual property and the medium in which that intellectual property is captured. The intellectual content, that is the content that you have written, is your intellectual property. It is fixed in a physical medium, which is pages of the book. Pages of the book are physical property. The contents of that book are intellectual property. So when we say you are an owner of an intellectual property, you are the owner of the content. It is with respect to that content that you get exclusive rights. These exclusive rights clubbed together are known as intellectual property rights. It's a very wide term. There are many types of intellectual property rights. And today, through this discussion, I want to throw light on the basics of those types of intellectual property rights, which I think are of most interest and of most utility to you as engineers and technologists. So, going to the various types of intellectual property rights, these are the various types of things or creations of mind that you can see in front of you. By using your mind, you can create images, broadcasts, logos, videos, computer games, inventions, perfumes. There's a very wide range of things which we can create using our mind. Now, each of these types of creations are protectable by intellectual property, but by different types of intellectual property. So, depending on the subject matter that we are looking to protect, intellectual property rights are divided into various types. Now, for example, if you've written a book or a research paper, the type of intellectual property right which will give you protection is called copyright. If there's a performance that you are making, the type of intellectual property right protecting that performance will be different. It is called performer's right. If it is a scientific invention that you have made, then the type of intellectual property that will be protecting you is called patent. So depending on the subject matter of protection, what is the subject matter that your mind has created, the type of intellectual property right will keep on differing. And we'll try today to cover some types of intellectual property rights. So for example, you can see in front of you this TV, which is a Sony TV. It is a creation of mind. A team of people have applied their mind to come up with this TV, to put together this TV. There are various aspects involved. One is the invention. invention of the technology on which a television functions, the invention of the remote which controls that TV, that becomes a subject matter of patent because it is a scientific invention. The user manual which will be written in order to tell us how to use this television will be a subject matter of copyright protection. The logo of Sony which is attached, which is affixed to the television, will be a subject of trademark protection. And the design of the TV. All TVs which are performing the same function may have different designs. Designs meaning the aesthetic designs. The design which we are able to see which contributes to the artistic or the aesthetic value of the product, not its functionality. That is referred to as industrial design. That design also becomes a separate subject matter of intellectual property protection. Now, basically, why do we need to protect intellectual property rights? There are two broad reasons. One is to cater to the interest of the creator. We want people to create more because ultimately more creation, more innovation would lead to greater progress. And in order to incentivize creation, we want to ensure that creators are granted some exclusive rights, some commercial advantage. Why would someone be incentivized to expend their time, labor, effort, both intellectual and otherwise, in order to create something, unless and until they are getting something in return? So some exclusive commercial advantage, that is why IPR says if you are the creator, for a fixed period of time, only you can reap the commercial benefits of that creation. So the first objective of IPR protection is to incentivize the creator. There is a second objective. The second objective is related to public interest. Ultimately, the creations should also reach the public at large. The society will not be able to benefit from the creation if it remains only in the hands of the creator. Therefore, the ultimate aim of IPR is to ensure that new knowledge that is being generated, new intellectual property that is generated should reach the public for everyone to use. That is why intellectual property rights do give commercial advantage to the creator, but only for a fixed period of time. That is the difference between physical property and intellectual property. In physical property, if you've purchased a plot of land, that land remains your property in perpetuity till you decide to sell it, till you decide to part ways with it. That is not the case with intellectual property. In intellectual property, you do have exclusive rights, but for a fixed period of time only, and the law fixes what that time period is. If you have created a scientific invention, you have a patent only for 20 years. If you've written a research paper, you have copyright for the entirety of your life plus 60 years. Statutorily decided time limits. Why? Because beyond that, we want that the knowledge should freely be available for all to use. It should not be monopolized only in the hand of the creator. So to strike a balance between the individual interest of the creator and the public interest, intellectual property rights create monopolies, but for a fixed period of time. That is why they are known as limited monopolies. Now we'll start with the first type of intellectual property right, which should be of interest to you, which is copyright protection. Now, as students and as engineers, copyright protection becomes important for you because what is the subject matter of copyright protection? The subject matter of copyright protection is one, literary works, anything that you write. Like I said, the notes that you scribble in your notebook in a classroom are your literary work. They are your original literary work. The paintings that you make, the music that you compose, any cinematograph film that is made, a sound recording that is made, a computer program that you may write, they are all works which are protectable by copyright. So in student life it is common, and thereafter also, you will be writing research papers. These research papers are subject matter of copyright protection. Okay. So when we say copyright protection, again, copyright refers to a bundle of rights. A bundle of rights. But what is the requirement of copyright? In order to get copyright protection, one, the subject matter for which you are seeking protection should be entitled to copyright protection, which means it should be literary work or musical work. But apart from that, it is very important to know that there is no copyright in ideas. There is no copyright protection in ideas. Copyright protection is available only to expressions of ideas. If you have an idea in your mind and you've merely communicated it to a friend, and your friend writes a research paper on that idea, who is entitled to copyright protection? Your friend. Because it is your friend who has expressed that idea. Copyright protection does not recognize ideas. It does not give protection to ideas, howsoever novel, howsoever groundbreaking that idea may be. But an expression in any form is given protection. Even if you're scribbling that idea in the form of a small concept note, that is also your original expression, which copyright law will protect. If you've written an entire research paper on it, that is also an expression which the copyright law will protect. It is also important to note that copyright law is not concerned with the literary merit of your paper. You may have written a very poor quality research paper. It may be making no contribution to the scientific discipline, but still it is your original expression. Therefore, it is your intellectual property. Copyright law is not concerned with how good or bad a research paper you are writing. Nobody is sitting in the registry to check the artistic merit of an artistic work, the academic merit of a research paper. What is required is an expression and an original expression. Again, what do we mean by an original expression? Copyright sets a fairly low bar of what is original. Now, if I narrate a film story in front of this classroom, I narrate a story, and I ask each one of you to write down the same story in your own words. Each one of you, without changing anything about the story, will produce a unique expression. The words that you use, the expressions that you use, the manner in which you structure your thoughts are going to be original. Even if the idea is the same. The idea is the same, but there is no protection for idea. And that is why on the same idea of each one of you are writing, using your own language, your own words, your own structure, it becomes your original expression, which is capable of copyright protection. That is why I said copyright is not concerned with ideas, it is not concerned with artistic merit, it requires originality of expression. So as long as your expression is unique, and it will be unique, it is not possible that any two of you will use the exact same words, exact same language, exact same structure to express the same idea. Therefore, all your expressions will be subject matter of copyright protection. So what copyright requires is originality of expressions, not originality of ideas, because idea is not protected. Had that been the case, we would not be seeing so many movies having the exact same story. So many movies that we watch have the exact same story. But yet they are all original works for the purpose of copyright protection. Why? Because the expressions are original. There will be a copyright violation if there is a scene by scene, dialogue by dialogue lift from one movie to the other. Because there the expression is being copied. Okay? So what copyright protects is original ideas. Now when we say copyright, you have a copy, you've written a research paper, it is your original expression, you have copyright protection over it. What do we mean by having copyright? So copyright, we say, refers to a bundle of rights. Bundle of rights, there are many rights that you get. Now the first and the most basic right that you get in copyright is called the right to reproduce, literally the right to copy. The right to copy. If you have written a research paper, only you can make copies of that research paper. Nobody else can make a copy. To reproduce that work in any manner, be it by clicking a photograph or by making a photocopy, only you have the exclusive right to make a copy. You have the exclusive right to issue these copies to the public. You have the sole right, the exclusive right to communicate this work to the public. I cannot stand on a public platform and communicate a research paper written by you to the public. Or if I am doing so, I am permitted to do so only for certain limited purposes. There are some exceptions to all these rights, as we will see. Like there are exceptions to right to property. Right to property is not a fundamental right in India. It is not an absolute right. No rights are absolute rights. There will always be exceptions to rights. Why? Because a balance always has to be struck between the individual whose rights are being protected and the public interest. So when an individual is living in a society, none of his or her rights can be absolute rights. There will always be certain curtailments. Similarly, in copyright also, these are exclusive rights but with some exceptions. We are going to see what those exceptions are. So what are the exclusive rights? Right to reproduce, right to issue copies, right to perform the work in public, right to communicate the work to public in any form. Communication to the public would include standing on a podium and speaking to the public. Communication to the public would include sharing that work on a WhatsApp group. That is also communication to the public. Then the exclusive right to make sound recordings or cinematograph films concerning a work, to make translations of your work, to make adaptations of your work in another form. If a research paper is to be converted into a book, if a book is to be converted into a movie, or vice versa, you are adapting the work into another form. Again, who can do so? Only the copyright owner. Only the copyright owner. He has the exclusive right, which means if anybody else wants to do it, they will need permission of the copyright owner and will also have to pay a sum of money to the copyright owner, depending on what the agreement is. If I want to convert your research paper into a book, I will need your permission. You can even ask me for money in return to let me incorporate your research paper in a book. And I also have to provide you acknowledgement because you are the owner of that property. You get to decide whether you want to sell it, whether you want to let me use it, whether you want to, how you want to commercially exploit your property is your sole decision because you are its owner. Now, who is this copyright owner? How do you know whether you are the copyright owner of a work? The general rule is that author is the first owner. Author is the first owner of copyright. But there may be a circumstance where, let us say, you are an employee of an organization and you have created a work in the course of your employment. If you are a copywriter in a publication house or in a, let us say, in a radio station or in a film or media house, and as a part of your job, you have written something. Now here, who will be the owner? Even though you are the author of a work that you've created for your organization, it is the organization who will become the copyright owner. Similarly, if you are working in a research institute, and as a part of your job for the research institute, you've written a research paper, then even though you are the author, but the research institute becomes the owner of copyright. But of course, this can be changed if there is an agreement to the contrary between you and the organization. At the time of taking up a job, accepting an employment, accepting a research project, you have the option of entering into an agreement with that institute or that organization that all the work that you create should remain your copyrighted work, or you will have the sole right to decide how that work is to be exploited. If there is no such contract, then the law lays down the general rule. According to the general rule, if the work is being done for an employer, then the employer becomes the owner. But this clause can be contracted out. So, ordinarily, like I said, it is the author who will be the first owner, and the author, by being the first owner, gets these economic rights. These are the economic rights of copyright because all these rights are given, because all these rights translate into an economic advantage. If you've written a book, you will want to earn money by selling that to the public, by distributing its copies to the public, by communicating that work to the public. So all these are economic rights because they translate into an economic advantage. And these economic rights come with an expiry date. Like I said, limited monopoly. Entire life of the author plus 60 years. After 60 years after the death of the author, these rights will no longer be exclusive rights. But copyright confers another type of rights which exist in perpetuity, which do not come with an expiry term. They are known as moral rights. Now, moral rights refers to two types of rights. You've written a research paper. The first moral right that you have is known as the right to paternity, which means that even after the expiration of your copyright term, I cannot publish that research paper in my name. That research paper can be commercially exploited by somebody else after your term expires, but only in your name. Your name has to be attached to your work because it is your intellectual creation. That is the first moral right. The second moral right is known as the right to integrity. It means that I cannot take your work and distort that work in such a way so as to harm your reputation. I take your work and I turn it into a scandalous adaptation, an obscene adaptation, and still give it your name. It will harm your reputation, it will harm your integrity. Therefore, these two rights are known as moral rights. Moral rights of the author, they remain with the author forever, even after the economic rights get over. Now, one very important point that you should know about copyright protection, because I am discussing this with you, keeping in mind the fact that you will be writing research papers and books for which you need copyright protection. Now, first, like I said, an important point to note is that for copyright, law follows the principle of automatic protection, which means that you don't have to mandatorily register a copyright work in order to entitle yourself for copyright protection. The moment you've created the work, it is your copyrighted work, you have copyright protection. The moment you've scribbled notes in your notebook, it is your copyright protected work, even though you've not applied for any registration. But as a lawyer, I will always advise you to get your work registered, because in the event of an infringement, in the event that somebody copies your work, in order to prove before the court of law that you are the author of a work, a copyright registration will come in handy. Therefore, it is legally advisable to get your copyright registered, and the registration process is very simple. You go to the website copyright.gov.in and you will find a very user-friendly, self-explanatory procedure for registration of any work as copyright. You can try it as an exercise. If there's any paper, any project that you have created, try registering it on the government website. It's a very simple procedure, but you can be assured that nobody will copy your work. And see, copying is very common. We should not be under the impression that if we've created a research paper, it is very safe in our hands, especially because to our knowledge we have not shared it with anyone. If one of your friends or someone who is not your well-wisher clicks a picture of your research paper and uploads it online, it is a short ticket to endless infringements of your copyrighted work. You should first be aware of the advantage that a literary work that you have created can bring for you. You are the owner of that property. You have the right, exclusive right, to commercially exploit that property, and you have the right to prevent everybody else from exploiting that property. So therefore, it is necessary to keep your copyright protected. Now, another very important point is regarding plagiarism. Now, all of you are aware of the idea of plagiarism. Plagiarism and copyright infringement, there is an overlapping zone between the two. However, plagiarism is a much wider term. So as researchers, we are concerned not just with copyright infringement, but with plagiarism also. Because unlike copyright infringement, which can be made only of expressions, copyright infringement means copying expressions. Copying and pasting somebody's written word as it is becomes copyright infringement, but plagiarism is much wider than that. Plagiarism is much wider than that because plagiarism can also be of ideas. So if you're lifting somebody's ideas without providing them due acknowledgement, then that amounts to plagiarism. And as researchers, we are about not only to respect others' copyrights, but also to ensure that we are not committing plagiarism. And plagiarism and copyright infringement have cost many researchers their jobs and their reputations. As you can see on the screen, there have been many instances in India where sometimes knowingly, many times unknowingly, we lift something written by others. It's usually a very common practice, especially in schools when we are younger. We don't pay much heed to copyright infringement. We are very used to copying and pasting content from the internet, from some other works that we may find, often without realizing that we may be violating the law. Just because copyright infringement is rampant, especially on the internet, does not mean that it is not a violation of law and that an action can never be taken. An action can be taken if the copyright owner of the work is diligent enough, vigilant enough to take that action against you. So that brings me to the end of a very brief overview of what is copyright and why copyright should concern you. So what you should be aware of is one, everything that you create, literary work, artistic work, musical work, irrespective of its merit, irrespective of its academic merit, its literary merit is your property. It is your intellectual property. You have automatic protection on that intellectual property, but it is advised that you get it registered. Registration, online registration is a very simple process. Simple, inexpensive also. And third, while writing research papers, you should be very careful that you are not copying anyone's expressions, means you are writing everything in your own language. You are not using somebody else's language. The moment you use somebody else's language, you are copying somebody else's language, you are copying expressions and therefore committing copyright infringement. Use your own language and give due credit to whoever's idea you have incorporated in your research papers. So this is about copyright protection. Now let us move on to the next type of intellectual property, which is especially important for those of you who are planning to one day have your own businesses, or even if you're planning to work in corporates, in various companies. The next type of intellectual property right becomes important because it is a type of industrial property. It is known as trademark. Again, all of you are commonly aware of what a trademark is. You can see many types of trademark in front of you. These are various logos which we find attached to various types of articles of trade and commerce. So a trademark is a mark which is attached to an article of trade and commerce, which may be a product or a service. This mark can be anything. It can be a name, a number. It can be a combination of colors. It can be a logo. It can be a drawing. It can be a shape of goods. Various types of marks can be called trademarks. Now these are called trademarks because what is their purpose? Their purpose is to distinguish between two products or two services, or a product and a service. As a consumer, when we go to the market, how can we differentiate between biscuit packets which are coming from two different companies? How do we identify which biscuit is produced by which company, or which is the biscuit that we want to buy? From its packaging, from the combination of colors, from the manner in which its name is written, or from the very name itself. All these marks are its trademarks. The manufacturers or sellers have over the years, by using the very same trademark, built a reputation in the market. As consumers, we are assured of the quality, of the source of the product or service that we are buying when we see the same mark being used. Trademark is protected by intellectual property law again for two purposes. One, to serve the interests of the manufacturer or the seller, the trader. The trader, if over the years Adidas has built a reputation for itself in the market. So if somebody else is using the same logo or a same name or a similar name, which is confusing for the consumer. If I see a shoe in the market which is called Abidas instead of Adidas, and if I'm not very careful, I might think that the shoe actually belongs to Adidas and will be in fact elated that it is available to me at a cheaper price, and may buy that product very happily. So as a consumer, I get deceived. As a trader, Adidas suffers a loss. Why? Because somebody else is copying that trademark. Therefore, it is important both for the trader as well as for the consumer that trademark is protected as an intellectual property. Again, when it is protected as an intellectual property, it means that nobody else can use that mark. Nobody else can use that mark apart from the registered proprietor, the registered owner of that trademark. Now, trademark has immense importance in business. The entire brand value of a company is built based on a trademark. There are many brands, in fact, there are many companies who put a lot of thought into designing their trademark, how their trademark should reflect their ideology, or their purpose. But though that is not compulsory, that is not legally compulsory. Your trademark can be anything. You may be selling a product or using a mark for that product that has absolutely no relation to the product whatsoever. So it is not necessary that your mark should have some logical relationship with the product that you are selling. But both for the purpose of advertising, that is generating brand awareness, building brand reputation, as well as for assuring the consumers that the product being sold is an original product. It's not a counterfeit. To assure a certain type of quality, trademark is important. In fact, like I said, the brand value of a trademark is built. Trademark plays a very crucial role in building the brand value. What is the role? It is an important question to ask. What is the role that a mark plays? Sometimes even when we don't remember the name of a brand, we remember a logo because the image of the logo will be fixed in our minds. Or if there's a small child who's going to a market to buy something who may not know how to read and write, but by seeing a certain combination of colors or seeing a certain shape of goods, may instantly recollect that this is the product that he or she wants to buy. So for consumers, the brand is often fixed in the mind in which the trademark plays an important role. And therefore, trademark is also protected. Now, when we discussed copyright, we said that copyright there is automatic protection. But unlike that, in trademark there is no automatic protection. If you want to use a certain logo or certain mark as your trademark, you will have to register. You have to make an application for registration of that mark as your trademark. The trademark registry will decide whether or not your trademark is registered. Now, there are certain factors that the trademark registry takes into account while deciding whether or not you should be allowed to register a trademark in your name or not. Factors such as the first factor is that you should not want to register a trademark which is deceptively similar to another mark. If you want to use this as your mark, if you want to register Nike as your mark, it is deceptively similar to Nike, and therefore the trademark registry will not register your mark because you are looking to commit a trademark infringement. If you are looking to register a mark which is scandalous, which is obscene, which is a cuss word, you cannot register a gali as your trademark. The law does not permit that. If it is a cuss word, if it's scandalous, if it is obscene, if it is hurtful of religious sentiments, that mark will not be registered as a trademark by the registry. If you want to register something as a mark, which is a very common word, which everyone will be required to use, again you will be denied registration because registration would mean a monopoly. Only you can use. If you are a seller of mangoes, you cannot trademark the word mango because that would prevent all other mango traders from using the word. Other mango traders should also be allowed to tell the public that they are selling mangoes. Therefore, a mango trader cannot trademark the word mango. Apple can be a trademark for a phone. It could never have been a trademark for an Apple company. The word apple cannot be used to sell apples. It cannot be a trademark for a trader of apples. It can be a trademark for a phone company because other phone companies are not required to use the word apple. So if you want to monopolize, if you are looking to monopolize a word which is commonly required to be used by other traders also, the trademark registry will not let you do that. So therefore the word should not be descriptive. It should not refer to a kind, quality, quantity of product which other traders will also be required to use. It should not be a scandalous word. It should not be deceptively similar with other trademarks. When we say deceptively similar, deceptive similarity can either be visual. Visually, the logo or the color combination is such that as a consumer we are getting confused between another existing brand and this new mark that you are looking to register. Or there should also be no phonetic similarity, like I gave you the example of Arbedas and Adidas. Phonetic similarity. When you are listening to the two names, they seem similar, or even visually it can be similar. Many people get confused between writing B and D as it is. So if I see Arbedas written in front of me, as a consumer, I am likely to get confused. So these are the points that the Trademark Registry keeps in mind, which are written down. These criteria are written down in the Trademark Act of 1999. And all these criteria will be taken into account before deciding whether to grant registration or not. Now, a trademark registration once granted, it is valid for a period of 10 years, but subject to renewal. Like we said, in order to build the brand value of a company, trademark plays a crucial role. So if after 10 years, if the protection expires, the entire objective of trademark protection will be defeated. And therefore, trademark is an intellectual property right, which even though in one go the duration of protection in 10 years, it is subject to renewal, which means after filling out a renewal application and payment of renewal fees, you can go on renewing your trademark. That is why the same trademarks have been used, the same logos and names have been used by companies since so many years. Okay, so a company can go on renewing their trademark every 10 years. Now we'll come to the next type of trademark. The next type of trademark, again, which is very important for you, is a patent. The subject matter of a patent protection is a scientific invention. A scientific invention of what do you mean by an invention? It's very crucial to note that the law has defined for the purpose of patent protection what an invention is and what a patentable invention is. Whenever you create something, you may think that you have invented something. Every time you have invented something, it may not qualify the definition of an invention according to the Patent Act. The threshold of originality of novelty that patent protection requires is the highest among all types of intellectual property rights. In copyright protection, the threshold was very low. Like I said, the artistic merit, the quality, doesn't matter at all. In case of patent, however, to secure a patent protection is extremely difficult. Because we have to understand what is the privilege that a patent confers on you. If you have made a scientific invention, a patentable invention, you make an application for grant of patent. If the registry is satisfied that you are fulfilling all the criteria for patent protection, a patent will be granted to you. Now, as a result, for 20 years is the time period for patent protection. For 20 years, only you can commercially exploit that invention. Only you can manufacture that invention, sell that invention, import, export, commercially exploit that invention the way you want to. Nobody else can. We have to understand how huge a monopoly it is. Because what are scientific inventions? Scientific inventions, first of all, are very crucial for the public at large. Let us say you've invented a medicine. You've invented an important industrial process. There's a huge public interest attached to the invention that you have made. Now, if you have invented a medicine and you are granted a patent, it means for 20 long years, only you get to decide what is to be done with that patent. Only you get to sell that patented medicine to the public. If you decide to sell it at an exorbitant price, so be it. So there's a huge public cost attached to conferring the monopoly of a patent. If you are an inventor who has the public interest at heart, then well and good for the public and good for the state. But as an inventor, because this is your private property, you may as well choose to not manufacture the patent at all. You may choose to manufacture and sell it but at an unreasonable price. You may decide to manufacture but only in a very small quantity that is not satisfying the needs of the public of this country. So it is while taking this huge risk that the monopoly is being granted to you. Why? Because the state realizes the kind of effort, money, intellect that goes into creating a scientific invention. Copyrightable works get created every day, but that is not the case with patentable inventions. Patentable inventions do not get created every day. So therefore, the first thing to understand is patent as an inventor is not your fundamental right. It is a state-conferred privilege. The state is granting a privilege to you The state is letting you use your invention for 20 long years. And why is the state doing that? Because the state has an interest in return. It's a quid pro quo arrangement. It is a give and take arrangement. In return, the state wants all the information relating to your new invention. At the time of making an application for grant of patent, you have to disclose everything about your invention to the patent registry. You cannot keep it a secret. Let us say you've made a groundbreaking invention. You cannot get a 20-year monopoly on it by keeping some secrets about your invention. You will have to divulge all information about your invention, all the technical details, how it is going to be used in the industry, everything in your patent application. It is only when the patent registry is satisfied that you've revealed all information plus satisfied all the requirements of patentability that this patent will be granted to you. There is no automatic protection in patent. You get a patent only if the patent office grants you that patent. Like I said, it's a state conferred privilege. State is granting you this privilege because it wants the new knowledge that you have created in return so that it can keep that knowledge to itself for 20 years, and after 20 years it can use that knowledge for the benefit of the public at large. So the first important point to know about patent is if you are developing a new invention, keep it a secret from others and do not keep it a secret from the patent office. Ma'am, do we have time?
Yeah.
We have time.
How much time are you?
Ma'am, I'll just complete patent and we'll stop.
Yeah. Please.
I'll just try to cover some important points. So what is an invention according to the Patent Act? The first point to note is that in India, you can get a patent over both a product as well as a process. Product means you've created a new product. A new medicine that you've created is a new product. But it's possible that you've created a new process to make the same medicine which is available currently in the market. This new process may be technologically advanced, or it may be a much cheaper process to produce the same medicine, in which case you can get patent only over the process. So a product or a process can be granted patent provided it fulfills the following criteria. The first criteria is that it should be a new product or process. The criteria is called novelty. Now, what do you mean by novelty? Novelty means that your invention should not be anticipated before. It should not be anticipated before either by a prior publication. If you are claiming something is your invention, but somebody has already talked in their research paper about this invention earlier, somebody has already spoken about this technology, written about this technology, or somebody is already using this technology in their industry, there is prior publication, there is prior use, we say that your invention is anticipated. Somebody has already thought about it, it is not your invention. Therefore, there is no novelty. Novelty requires that there should be no prior use of your invention, there should be no prior publication. So even if you are developing an invention, before making a patent application, remember, do not talk about it in conferences. Do not write a research paper about it and publish it. That amounts to prior publication. That amounts to anticipation. If you are the only one who has done it, it will not defeat novelty for you, but somebody else will read that paper, will hear your talk in a conference, and may develop on that idea on similar lines, or may make an invention which will ultimately create a conflict if both of you are to apply for patent. So the first criteria is novelty. Novelty means your invention should not be published before, it should not be used before. The second criteria is that of an inventive step. See, it is not every invention is not a breakthrough. The person who created a phone for the first time was eligible for a patent, but every time somebody has made an improved version also, the person who's making such improvement may be eligible for a grant of patent. So what is the requirement of patent? The requirement of patent is there should be some inventive step. Now, what do we mean by inventive step? This inventive step, the law says, can be in two ways. Either there is some technological advancement or economic advancement. Even if there is only economic advancement, so currently if the manufacturing process to produce this phone costs 100 rupees for the production of one phone, and you invent a process which is now costing 10 rupees to produce one phone, it is an inventive step. Why? Because there is an economic advancement. So for this economic advancement, you will satisfy the criteria of inventive step. Now this inventive step should be such that it should be non-obvious to a person who's skilled in that art. See, I'm a lawyer. So if you tell me something about a physics invention, it will all be new and non-obvious to me. That is not the marker. The marker is a physics expert. If it's a physics invention for which your patent is granted, someone who's an expert in physics should find it non-obvious, should find the step as inventive. Okay, so the lens is that of an expert in that field, not of an ordinary or a lay person. The second criteria is inventive step. The third criteria, very important, is that of industrial application. Howsoever brilliant your invention is, if you are not able to explain in your patent application how it can actually be made or used in the industry, you cannot be granted patent. Like I said, the state is giving you privilege for 20 years so that you can commercially exploit. If you don't know how to commercially exploit it, the state will not grant you that privilege for free. So you should be able to explain, prove in your application that there is no prior publication, you have satisfied the criteria of novelty, you have satisfied the criteria of inventive step, and third, you have satisfied the criteria of industrial application. You should be able to tell the patent office how your invention can be made or used in the industry. Apart from this also, the Patent Act lays down the lists of inventions which are excluded from patentability on the ground of policy. For example, if you've made an invention related to atomic energy, you cannot be granted patent. We don't want to take that risk. It doesn't want to take that risk of giving a 20-year-long monopoly to an individual who has invented something related to atomic energy. Similarly, there's a list of inventions or a method of agriculture in India. One person will not be allowed to patent it. So similarly, there's a list of inventions which, even though they may satisfy the criteria of novelty, inventive step, and industrial application, will still not be granted patent as a matter of policy, because there's an overriding public interest involved in denying patent. So if all these three criteria are satisfied, then the patent office will grant patent. Now for inventors, again, one very important point. I want to tell you some important points, therefore, if you're looking to file for a patent, is first, do not write articles, research papers, speak in conferences about your inventions. Second, do seek professional advice at the time of drafting a patent application, because it takes a techno-legal expert to draft a proper patent application. Now, the next point is, again, very important point. The patent office allows you to file what is known as a provisional application. Provisional application means your invention is still in the making or some final work is remaining. You don't have to wait for your entire invention to be developed to file that application. Patent system follows the first to file system. If you are the first to file, you will get priority over that patent. The moment your invention, you are sure of what that invention is going to be, but some work is remaining, you file the application and get a priority date in your favor. Thereafter, you are given a time period of 1 year. You have an additional 1 year thereafter to give fine touches to your invention before you can file the entire complete application to the office. But the moment you file that provisional application, you become the first to file for that invention. Which means that between that one period of time, if somebody else who's working on a similar invention files a complete application also, you will still get priority over that person because you were the first to file. Okay, so remember the first to file system, and this is a very important provision that the law has made, that it allows you to make a provisional application. Provisional application will simply need the title of your invention, an abstract, the basic functions, and it will buy you a time of 1 year. But at the same time, it will secure a priority for you with respect to grant of patent. So keep your invention a secret from everybody else and divulge everything to the patent office if you want to be granted a patent. Now another, ma'am, just the last point that I'll cover with respect to patent is that because the state is granting you a very important privilege, the state expects you to make use of that privilege also. So if you're not using that privilege yourself, if you're not making your invention, if you're not manufacturing, selling your invention, you're just sitting on that invention, the state will take away that exclusive right from you. Or if you are manufacturing and selling your product but in very small quantities at exorbitant prices, the state can make it compulsory for you to license the manufacturing selling to somebody else. This is known as compulsory licensing. This can happen, however, only after 3 years of time. After 3 years, after you have received your patent, the state grants you 3-year time. Within these 3 years, if you're not doing anything about your patent, you get ready for a compulsory license. Compulsory license means what? You will mandatorily have to give permission to somebody else to manufacture and sell the product because you are not able to do so. In return, you will get some money because it is your patent. But you cannot say that only I will manufacture and only I will sell, even if my manufacturing and selling is not satisfying the requirements of the public. And this may happen especially if you've made inventions such as medicines. There was a multinational pharmaceutical company who was making medicine, which was making medicine for final stage of liver and kidney cancer, called Bayer Corporation. Bayer Corporation is the multinational pharmaceutical corporation. Now they used to sell their, the medicine was their patented drug. They used to sell the medicine in India, but again the quantity was not sufficient to satisfy the requirements of the Indian public and the cost was also very high. As a result of which, an Indian pharmaceutical company called NATCO, they applied for compulsory licensing. They said that we are willing, allow us to make the same medicine. We will make the same medicine, but we will produce it in larger quantities and sell it to the public in India at a lower price. And the Patent Office as well as the courts of India have compelled Bayer Corporation to grant this license to the Indian pharmaceutical company. So if you are not working your patented invention in such a manner so as to satisfy the requirements of the public, you can be compulsorily made to license your invention to somebody else. This is also an important point to be kept in mind with respect to patent. So with this I stop. Actually there is one more type of intellectual property that I wish to discuss with you, but due to paucity of time it will not be possible to carry on. So I hope whatever of the brief overview that I gave you has given you some perspective regarding the significance of IPR for engineers. And if there are any questions, we can take those questions. Yes?
Ma'am, even if you file a patent in India, is it universally applicable?
No, I'm very glad you asked that question. All intellectual property rights are territorial rights. There is no worldwide patent. If you apply for a patent in India, your patent protection is restricted to the borders of India. However, you can make patent application in other countries also. You can apply for patent in all countries. Depending on whether you are satisfying the legal requirements for grant of patent in each country or not, it will be decided whether that patent office grants you patent or denies you patent. And for the purpose of simplifying the process of making applications to various countries, we have an international filing system, which is known as the PCT system. There's an international treaty called the Patent Cooperation Treaty, and India is a member. So it simplifies the process of making applications to various countries, but ultimately whether US wants to grant you patent or not will be decided by US Patent Office only. Whether Australia wants to grant you or not will be decided by Australian Patent Office only. So we have an international filing procedure, but there is no worldwide patent. Patent in India will mean protection only in India, not anywhere else. Yes. And it's the same for all types of IPRs. IPRs are territorial rights. Because the requirements of grant of IPR protection, they differ from country to country. What is patentable in India may not be patentable in another country and vice versa. Any other questions?
Can I go again?
Yes, please.
Ma'am, Ma'am, as you talk about the anticipation as well, what if the anticipation was done by some author or somebody, but who lacks the technical knowledge of that thing?
That will also count as anticipation. Like I said, the threshold of novelty for patent protection is very high. That will count as anticipation, yes.
What were the other intellectual property rights that you just named them?
I wanted to cover industrial designs and trade secrets also.
Okay.
So we can stop here today because time is up. And I hope I get more opportunities to discuss this with you because IPR happens to be very important for engineers. Thank you so much.
Okay, so let us all thank once again Dr. Jivita Bhage for the wonderful I hope that information was useful for all of us. I mean, although she is even interested in talking about the remaining two, and we'll see any possibilities in future when we could invite her again and she could enlighten us on the remaining two topics. So let us thank ma'am with the token of love from IIIT Nagpur. Thank you.